Okay, thank you very much for this very interesting presentation. And corporate law, unfortunately, inevitably lacking behind practice and all the things that can be created in practice, unfortunately. I'd be very much in favor of more fluffy bunnies and kittens, though. And we're grateful that the UK has put in place Section 172, because at least that gives us a tryout for all those countries on what not to do or how to change it, as you have aptly demonstrated. Okay, then we'll go on to the next speaker, who is Professor Karsten Engsig Sørensen, who is going to talk about how we can balance flexibility and credibility, and by doing so by looking at the special company forms for social enterprises and certification schemes that exist for these enterprises. The floor is yours.
Thank you, and thank you for this opportunity to present this paper, which I've written together with a colleague, Mette Neville. The paper is about social enterprises, which of course we have had for a long time. But what really triggered our interest for this topic was the fact that we discovered that a lot of countries around the world has introduced special company law regime to underpin or support the development of social enterprises. Of course, they have done a lot of other things, like introducing tax schemes and other incentives, but what really was interesting to us was the fact that we have special company law rules. And if I should try to link this topic to what we have discussed earlier today, then of course this is of course a topic which is separate from general company law. But you may say that these special regimes are more alternative or a supplement to the general company law. But nevertheless, I think there might be at least some lessons to be learned for general company law, to the extent that some of the ideas we discussed this morning has actually also been discussed in relation to social enterprises, and some of them have even been tried out there. So there might be some lessons to learn. Of course, there is also a complicated intermix in the fact that countries who have implemented social enterprises and special regimes for them may argue that they have done enough for social purposes. So if you came to Denmark and asked them to change the general company law, they would probably argue that now they've just introduced special reform for social enterprise, then that should do it. And so maybe there is a kind of competition here. I'm not sure how we should see that. But nevertheless, I'll try to go through the paper, which is about these company law regime, and we were trying to look into different solutions and also trying to see how they work. And we discovered that there, of course, is a schisma. There are many schismas in these social enterprises. One of them is, of course, that they have to balance somehow to give some profit for the investors, and on the other hand, to do some social good. And this, of course, is a balancing in itself. But also we discovered that there are two challenges. First, of ensuring flexibility, so that these social enterprises does not become something which is only for a very small enthusiastic group of people who wants to take this on, but also is available for a broader group of entrepreneurs and companies. And then, on the other hand, there is the question of credibility, because if we are creating a special corporate form or a special certificate for social enterprises, then of course we want to make this a credible brand, and to do that we have to make sure that those who are within that set of rules, they're actually also doing something for the society. So we examined the three different regimes mentioned there, and the benefit cooperation has now been implemented in the majority of US states. The UK community interest companies have been there since 2005, and I think there's now more than 8,000 of them, so it's been a relatively big success. And then the Danish rules, which is a legislation which is pending at the moment, but which we reckon will be adopted in early next year. So the first question we discuss is whether or not to adopt a new corporate form or a certification scheme. And we of course study what has happened in other countries and see that they have often chosen to introduce a new corporate form, and we see some advantages in doing so, because then you could really introduce the ultimate corporate legislation for these particular kind of companies, and legislation which serves their need and also which then has a special brand. But the main disadvantages are that you then forces those who wants to, or existing companies or enterprises who wants to become a social enterprise, you forces them to enter into this special regime, and there of course there is a lot of switching cost, and also there are certain kind of enterprises which we don't think are likely to switch. For instance, cooperative often feel they have a special identity in the fact that they are cooperative. Whereas certification schemes may be the more flexible solution, at least this is our conclusion, because it allows basically all companies, disregarding the form they have, to opt for this regime, and they can keep the form they have. The disadvantage is that we discovered that it's very difficult to formulate a requirement as to capital and to management for a broad range of companies, different corporate forms, because then you actually go in and dictate what the management should do, but who is a manager in different companies and so forth. So actually it's kind of tricky. Of course it can be done, but it really requires you to think through each corporate forms which may elect to become certified to make sure it works perfectly. Also, of course, you have to make sure that company law does not bar you from becoming a social enterprise, for instance, by dictating that the profit of the company should be allocated to the shareholders. Because if that's the case, then of course they wouldn't be able to be certified, at least not under the regimes in Denmark, proposed in Denmark. And actually we did find that some of the Danish corporate forms can't opt for this regime because of that. Here are the key issues, and I won't be able to go through that. It's all dealt with and compared in the paper. There are some issues, of course, what you should do to become a social enterprise, and the most important one is probably how to ensure that they do state their special social purpose. And what requirement and control you should have in relation to that. Of course, this is a special problem, and it's not really related to what we discussed earlier, where we discussed how to maybe to some degree ensure that companies are also acting sustainable. But here we want to ensure that these social enterprises, they are actually doing something specific for the society as defined by themselves and accepted by the legislator. We also have special regimes for the management of these social enterprises, and as you can see from the points I've mentioned here, actually many of the topics we have discussed earlier have also been either discussed or even regulated in social enterprises. Whether or not you should reformulate the management's duties, which they have done in some countries, in Denmark and in the US actually. Whether you should have stakeholder involvement, it's been discussed. It hasn't really happened. There is, of course, stakeholders consultants. I think the closest they come to stakeholder involvement is that they, in some US states, have a benefit director, which is one of the directors who is just appointed with a special task of ensuring that the social goal is actually achieved. So it would be very comparable to this risk director, which I think Blanett mentioned just earlier. And then, of course, the enforcement issue, which is also well, there are some special good lessons to be learned. I think the UK solution, where they actually have a public authority, the regulator, who is taking on complaints, including from stakeholders, and then has a lot of possibilities of interfering into the social enterprises, is actually worth examining closer, because it could be a way of enforcing the management duties. But the most complicated, or at least what's where we have the most provision, company law provision, is on asset locks, and then we have some reporting requirements. Let me just go through some of these points. I don't know how much time I have left. Okay. This is something new and something we haven't really discussed yet, but for social enterprises in the UK and also in the Danish pending legislation, they have chosen the solution that there should be some restriction on how you can transfer money from the social enterprise to the shareholders. And the underlying idea is that we want to make certain that they don't take away the whole profit. We want to make sure that some profit stays there and is able to be allocated for the special social purpose which the social enterprise have chosen to pursue. So you can see they have put a cap on dividends. There's a maximum of 20% interest in the UK solution, but that should be coupled with the fact that you can only use 35% of the annual profit for dividends. So it's probably not very likely that they'll get the 20%. They can only get a third of the, approximately a third of the profit each year. And in Denmark, it's even less. You can get a reasonable annual return, which I guess would be a few percentages. So actually, they have really limited the amount of profit the shareholders can get. And then, of course, there's a lot of rules ensuring that they don't take it out in other ways, like buybacks, buying back shares, or lowering the capital, or high salaries for directors, etc., etc. So they are trying to really make sure these are effective. So I have posed two questions at least, which I think is worth discussing. And one of them is whether there is the right balance between the social purpose and the dividends to the owner, because actually these are quite restrictive, especially the Danish solution is quite restrictive, and it may be that it will not be attractive to that many entrepreneurs or investors to be part of that type of company. And I don't see why you need to be that strict. It could be that if they lose maybe half or a third of their profit, that would even be enough. Or if they are doing a lot of good when conducting their business, it would still be a very beneficial thing and could still be qualified as a kind of social enterprise. But at least it's worth a discussion whether it's too strict. But the other one is that it's kind of a funny solution that to make sure that they pursue a social goal, you, instead of dictating that they should do something positive to benefit that social purpose, you are actually just making sure that the shareholders don't take the money. How does that ensure? Of course, there is an indirect effect that if the shareholders can't take the money, they might think, okay, then let's give it to the social purpose. But actually, it's a kind of a funny solution, and therefore it's worth discussing. So I think my conclusions have been mentioned on the way, so I don't think I'll repeat them here, and I'll end my presentation. So thank you for your attention.